Fantastic. So it's 2 o'clock. So there's still people joining us, but we are going to get started because we've got a lot to get through, and we've only got half an hour for this first session. So this is the first of 4 of our webcasts on the Employment Rights Act. Today we're going to be going through dismissals and the new regime around fire and rehire, and also contract variations. The date for our next one, which is around the family-friendly rights and flexible working, that date has now also been released. So Dawn will drop that into the chat as well for people who want to join that one. There we go. Thanks, Dawn. And this is also going to form part of our new e-learning offering. So what you're hearing today is half an hour of what will be a more detailed 1-hour session that will soon be available on our e-learning platform, as well as part of the 4-part masterclass, as well as the resources and freebies that we're going to be giving away. So I've got the list of those at the end of this session as well. So we're going to get started because, as I've said, there is a lot to get through today. I'd like to try and leave a little bit of time for in case there are any. This is still an emerging situation because we're waiting on regulations to give us a little bit more detail. But now that we do have the Act, we've got royal assent, we have got a little bit more clarity than we had a couple of months ago. So today we're going to be looking at the new dismissal risk, so understanding the implications of the new 6-month time limit before someone can bring a claim, the removal of the compensation cap, and what changes you need to be implementing around your approach to early employment decisions, lawful probation management and things that we need to be thinking of around probation, and also contract change navigation, so understanding the compliant approaches to contract variation going forward and the prohibited practice of fire and rehire. So how has the legislative landscape shifted? So we now have the Employment Rights Act rather than the bill. So thank you, King Charles. On the 18th of December, he handed every employment lawyer probably the worst Christmas present we could ever have had, which is a 350-page act to read and get our heads around. And not to mention the swathes of secondary legislation that we're now going to need to bring lots of that into effect and to give us the fundamental detail that we are going to need. However, what we're going to look at today is the removal of the 2-year qualifying period, with that now being replaced to a period of 6 months. That's going to come into effect on the 1st of January 2027. And this is kind of going to be retrospective. So anybody who has been employed from the 1st of July 2026 and who is still employed by the 1st of January 2027 will have that 6-month qualifying period, and they will have the right to bring a claim from the 1st of January 2027. We've then also got increased compensation exposure. So there's currently limits on what someone can claim for unfair dismissal. So the basic award is limited to £21,570. Compensatory award is limited to 52 weeks pay or 118,223, whichever is the lower. These are going to be removed in 2027. So this is likely to affect tribunals' hearings in 2027. So if you dismiss somebody now, and their claim doesn't get to hearing until 2027, those limits could well apply to you at that point, because we are looking to 3 years down the line in some areas for tribunal hearings at the moment, particularly where there's a discrimination element to them. Fire and rehire restrictions, so the controversial practice of dismissing employees to impose new terms. So say, for example, there's an issue with your contracts, or there's something that you're not happy with and you want to change a contract and an employee isn't happy about it. At the moment, we can kind of go through some consultation and then say, well, look, if you're not happy about it, we're going to give you notice and dismiss you, and then offer you a new contract that commences immediately on the new terms. That as a practice is going to come under some significant restriction. Dismissals will be automatically unfair if someone has been dismissed through that process from October 2026. And it's going to be very difficult to vary contracts going forward once they have been issued. But we're going to go through that in more detail through this session. So let's get started with the 6-month unfair dismissal limit and what that means. So as I've said, from the 1st of January, anyone who's been employed at that point by 6 months will have the ability to bring an unfair dismissal claim, and that will also include constructive dismissal, so where someone is resigning and claiming that you have breached their contract of employment. What this means is we are losing that 2-year sense of security, so that safety blanket that we felt that we've had for the last however many years this has been in place. I do remember being in practice when it was 1 year, which may give you an indication of how old I am. However, we now need to be ensuring that we are making better hiring decisions. We all know how quickly that first 6 month period can pass us by. If I had £1 for every time I'd spoken to a client and they told me, oh, it was 6 months probation, we meant to do the probation review, 6 months has just come and gone and we haven't done the meeting yet, what does that mean? I would be very, very wealthy and I wouldn't be doing these webcasts. It is something that happens in probably every single business. Is these months absolutely fly by, and before we know it, someone has been in the business 6 months, 9 months, 12 months. So where is this going to impact us? So hiring decisions, we need to be making sure that we are thorough on that pre-employment screening, that we've got robust probation structures, and we're much, much clearer on role specifications, what's expected, what's going to happen when somebody is in employment with us, and try and reduce the risk of early exits. We need to be making sure that we have a proper process for managing probations so that anyone who starts with us understands that there will be a number of performance reviews. We will be checking in to see how they're getting on. We will be documenting them. We will be giving feedback. And if formal improvement plans are needed where concerns arise, those will be implemented and documented. And that when we are exiting people, that these are done with documented rationale and that we are following procedure. One of my favorite things to say to clients is, if you are dismissing someone either on the basis of performance or as a result of a failed probation, it should never, ever come as a surprise to an employee. It really, really shouldn't be a surprise if someone's being dismissed because of performance. If we've got someone who sat in that chair who's being told that they're losing their job because they're not performing or because they failed their probation, and they say, well, I never saw this coming, that gives us an indication that perhaps the situation hasn't been particularly well managed. So we have got a poll. If you want to have a look on, I think it's on the right-hand side of your screen. So which statement best reflects how probation is currently managed in your organisation? We treat probation as a low-risk period with minimal formal processes. We give feedback, but documentation is inconsistent. We have structured reviews, evidence and written feedback from day one. And I'm not sure what the formal probation process is in my business. So we're seeing a bit of a nice spread across the first three. I'm glad to see that we haven't got anyone who doesn't know what their formal probation process is. But I'd say that actually that split's about what I would expect. So it's going to be really, really important that we have a think about, well, what should those first few months look like? And really, do we want to be leaving it to that 6 month period before we are making those exits if we need to? Realistically, we should know by 3 months, 4 months tops, if somebody is right for our business or not, and we should be engaged in those formal processes at that point to make sure that we are not accidentally slipping past that 6 month process. Because at the moment, and it's something that catches employers out, that if we've got someone who has been with us for, say, just shy of 24 months, so perhaps 23 and a half months, and we issue notice to dismiss, and that notice tips them over the 2-year deadline, their employment is then protected. And the same will apply with this 6 month limit, that if you dismiss somebody at the last minute and you inadvertently issue notice either that's going to be worked or whilst they're on garden leave, and we're not paying in lieu of notice to bring that employment to an end immediately, then that person is going to trip over that 6 month tripwire, and potentially there's going to be legal risk. So probation, what it is and what it isn't. So there's a critical misconception that probation periods provide this dismissal, low risk or no legal consequence zone where termination requires a minimal process. And this has never been true, but it's certainly now a very high risk assumption. 6 months, as I've said, passes extremely quickly, and the habit of not documenting things during the probation periods does need to stop. Now, what I'm seeing as a trend in practice, and this is particularly around people who are either lower earners or particularly those who are in those first 6, 12 months or 18 months of employment where they lose their jobs. They know that they don't have the right to claim unfair dismissal. And we're seeing an increasing number of people being able to get themselves diagnosed with neurodiverse conditions and then claiming disability discrimination. So we are seeing those disability discrimination cases rocket in the employment tribunal. I'm seeing in practice a huge increase in the number of threats of discrimination proceedings. So we can no longer treat these probation proceedings as low risk. We need to assume that either everybody is going to have something that's going to give them some additional protection, because then that means we're going to approach everything with a high risk attitude, meaning we're more likely to be compliant. And it also means we're less likely to get caught out and have to clean things up later on. So reasonable things that we need to be thinking about is making sure when people start that we give them adequate training, we are establishing clear performance standards, we're offering regular feedback, and that we're ensuring genuine opportunities to improve. And it should be the probation period should be viewed as an extended assessment period, not just an exit route. And remember, discrimination can be brought from day one or before if your recruitment processes are defective. And we also still have automatic unfair dismissal. So these are special grounds that people can bring an unfair dismissal claim from day one of employment. So it's not an entirely risk-free zone. So the automatic unfair dismissal list is on the screen. This deck will be made available afterwards, but just to kind of fly through those, we've got pregnancy, childbirth, maternity, health and safety activities, statutory right enforcement, jury service, trade union membership and activities, assertion of statutory rights and protected disclosures. There are some in there that are very, very broad. So things like assertion of statutory rights, that's often bent and twisted into all kinds of directions to try and get unfair dismissal, automatic unfair dismissal. But we are seeing under the Act new additions to this list. So sexual harassment is kind of coming in through the back door because that's now going to be considered a protected disclosure. So if somebody raises a complaint about sexual harassment, that will be included as one of the protected points that you can complain about as a protected disclosure. If you dismiss someone for making a protected disclosure, it's automatically unfair dismissal. Contract variation. So as I said in the intro, if we dismiss someone for not agreeing to contract variation, that's going to be automatic unfair dismissal. And then we've also had the removal of the 12-week time limit around taking part in industrial action, which we will cover when we do the trade union session. So we've got new additions to this list on automatic unfair dismissal, and that sexual harassment one really, really is key because it's not immediately obvious from the drafting of the legislation that that's in there because it now comes under that definition of protected disclosure. So to wrap up on this section, make sure that we're managing probations properly, we're setting clear expectations, we're documenting what we're doing, we're mapping out what probation looks like and we are sticking to it, that we use job descriptions and profiles, that we're pre-setting review meetings and we've got structured outcomes and we're documenting those. Our SaaS software actually does this for you. So you can set out probation periods and review meetings before somebody even starts. And we have got clear guidance around dismissals and processes built in there to help keep this low risk for you. And also we're going to be rolling out across our e-learning as well to support managers and HR around dismissals during probation and also disciplinary sickness absence. And training around that to help keep you nice and upskilled during this period. Make sure that we are providing evidence, so maintain contemporaneous records of concerns with specific examples of underperformance and any support or training that's been provided. So all probation review meetings, any feedback that's been given, training that's been offered and progress that's been done on those courses and discussions regarding performance issues. Making sure that we are giving warnings. If it isn't going well, make sure that the employee is aware. And make sure that we are also allowing reasonable time for improvement. So the question on there, is there still a risk if you dismiss on the 6-month mark but pay pile on instead of serving the notice? So if it's actually on the 6-month mark, there's going to be the argument over when that anniversary actually passes. So if we take it the day before, just to keep it low risk, you need to be very, very clear in your outcome letter that their employment ends immediately and that payment in lieu of notice is being made. So we have to be very, very clear on the outcome wording if we are going to be doing a pile on. Because if we're vague with the wording and someone thinks that they're being paid essentially to sit at home and not having to work their notice, then that would be a risk. Okay, so new prohibitions now on contract variations. So there's two areas here that we're going to look at, but they kind of mesh together. So we've got a total ban on certain contractual changes once that contract is in place, and then we've got permitted variations where it's reasonable. So we're going to go through the wording and the areas where we've got the total ban, and we're also going to talk about permitted variations. And then we've also got this practice of fire and rehire. So where contract variations don't go the way that we want them to, we can't get people to agree, and this practice of ending contracts and then rehiring people. We're going to go through that as well because these two areas, like I say, are very much, they mesh together. So the new rules are inherently connected and we should be considering these together. Where we've got failed negotiations, this is where we then end up with a high risk situation regarding potentially automatic unfair dismissal. This is coming in from October 2026. So this is something that we're going to have to start to get our heads around relatively quickly. So what does the legislation say? Well, what we have got within the Employment Rights Act 2025 is a whole new section that's getting dropped into the old Act. This will go in at section 104. And this will say contracts of employment restricted variations. An employee who is dismissed is to be regarded for the purposes of this part as unfairly dismissed. That's it. They are unfairly dismissed. It's automatic. There's no test around reasonableness, fairness, or any of the other stuff that we typically have to consider when we're looking at unfair dismissal. It's automatic. If the employee was employed by a business and the reason for the dismissal was because the employer sought to vary the employee's contract of employment and they wanted to make a restricted variation. So let's have a look at what the restricted and unrestricted variations are. So restricted we have on the left. As I say, don't feel that you've got to furiously take notes because we will be distributing the deck afterwards. A reduction or removal of entitlement to any So if, according to how much work is delivered, pay is linked to that measure, if we're changing that, that would be a restricted variation. Any terms or conditions relating to pensions or pension schemes, the number of hours that somebody works, variations of timing or duration of shifts, reduction of the amount of time off that somebody gets, the inclusion in a contract of employment a term enabling someone to make these changes, and then the one that we always hate, the Secretary of State can add further categories. So this could be very fluid. And if an employee is dismissed or made redundant and then they are replaced with someone who isn't an employee, and it's clearly to get around these provisions, then that will also be automatically unfair. So we can't contract around this. We can't put a variation clause in that's going to allow us to make these changes through the back door. Then we've got unrestricted changes. So what we mean by unrestricted is if we are going to force these changes through, we then have the test around whether something is fair or unfair, and I'm going to come on to what that test is in a moment. Anything that isn't included within that restricted list would technically be classed as an unrestricted reason. However, what we do need to bear in mind is that the Secretary of State can amend this list. So we need to be really, really careful that, one, we're not being a bit loose with terminology to try and get around any of these restricted reasons. If at the fundamental crux of what we are doing, it does anything that's on the list on the left, it is a restricted variation. If we're happy that it's unrestricted, then in deciding whether or not something is fair or unfair, the tribunal will look at the reason for the variation. So what business reasons have we got? What consultation was carried out? If an employee is a trade union member, whether consultation was carried out with a trade union. If there isn't a trade union, but there's other representatives present, if we carried out consultation with them. If anything was offered to an employee in return for agreeing to the variations, and then any other points added by the Secretary of State, if they're added into this list, that's then going to go towards that test for fairness or unfairness. So if we are going to go through contractual consultation and potentially contractual change, we need to make sure that we're very, very clear on our business rationale. I do not expect that flippant reasons or things that aren't business critical or business essential are going to be permitted onto this list when we're looking at reason for variation. So it's going to be really important we're clear on why we're doing something, why it's important, and also that we've got this consultation process properly mapped out and that we can evidence that we've also done it properly. So quick poll there on the screen. So from January 2027, this is a little knowledge test here for the last section, see if we're all listening. From January 2027, how soon can an employee bring an unfair dismissal claim? 11 of you still think it's day one. It's not, 6 months. After 3 months, after 6 months, after 2 years, after 6 months of employment, but from that 1st of January, if someone has been employed for 6 months, by that point, they will be able to bring a claim. So it's not the day one rights. We lost that, thankfully, when we went to the House of Lords and we've had the amendments and the ping pong with the legislation. It is 6 months. So back to fire and rehire, understanding the prohibition. So the practice of dismissing an employee to impose less favourable contract terms, formerly known as fire and rehire, is now prohibited except in limited circumstances. So if it is a restricted variation, you cannot fire and rehire. There is a total ban if we're doing this for those restricted reasons. If we are doing contract variation and it's not for a restricted reason, we've got to make sure that we're following at the very least those key points that we just set out that were on the right-hand side of the previous page, and making sure that we can justify what it is that we're doing. So what conduct is now banned? Dismissing an employee with the primary purpose of re-engaging them on less favourable terms, threatening dismissal to pressure acceptance of contractual changes, using the threat of closure or redundancy to coerce agreement, or creating artificial redundancy situations to circumvent consultation requirements. It's very, very politically sensitive. This is something that trade unions and the press jump all over. So if you are caught doing this, it's likely to result in press coverage, particularly because it's a very new law, and it's also going to be automatic unfair dismissal. If we need to make a restricted change because we are at a point where the business is essentially facing insolvency, there is going to be essentially a carve out that allows us to make those changes. But the commentary that we are seeing around that at the moment is essentially you have to be at the point where your business is about to fail. The test is going to be very, very high for that. So as we get more guidance around what that threshold is, obviously we will be either updating our sessions, updating the training that we're doing, or putting out more materials on it. But the message that we are leading with essentially is stay away from those restricted variations if you possibly can avoid it. Because if you cannot get employee agreement without essentially threatening people, you are going to be facing automatic unfair dismissal claims. Because if someone resigns in response to that behaviour, it's going to be automatic constructive dismissal. So common and lawful scenarios, if someone were to say, accept these new shift patterns or we'll have to let you go and recruit on new terms, we won't be able to do that. Announcing redundancies in one department while simultaneously advertising similar roles with reduced terms and conditions, or serving notice of termination whilst negotiating re-engagement on substantially worse pay or benefits. So lawful approaches to contract variations, individual consent. So if someone gives individual consent, it's clear, it's voluntary, and we've got documented agreement. Employees must understand what they're agreeing to and have a genuine choice without duress and threat. Where the changes affect 20 or more employees, collective consultations required, meaning that we need meaningful engagement with employee representatives and considering alternatives and proper process. And we also need to be checking our current flexibility clauses, because the likelihood is that many flexibility clauses within our current contracts that are issued are no longer going to be fit for purpose. These are going to have to be very, very carefully worded, because if they are too wide, it will be classed as one of those restricted variations, and trying to enforce it could potentially result in a automatic unfair dismissal claim. So what managers must not do: never say this is changing whether you like it or not, sign this or consider yourself redundant, everyone else has agreed so you need to as well, or we'll just hire someone else on these terms. Always remember, consult HR or legal before discussing any contractual change going forward. Allow reasonable time for consideration, document all discussions and decisions, and avoid any language that could be construed as threatening. All significant contractual variations should require HR and legal sign-off going forward before it's communicated to employees. And ideally, we want managers lacking authority to unilaterally impose changes until this is bedded in and we've got a little bit more accustomed to it. So practical scenario here for an early probation dismissal. So Sarah, a marketing assistant, has been employed for 8 weeks. Her manager, Tom, believes her work quality is below standard and wants to terminate her employment before the end of her 6-month probation. Tom has mentioned concerns informally, but has not documented issues or provided formal feedback. Time is running out, and in response to the meeting request, Sarah has gone off sick with stress, with a sick note ending after the 6-month period. She also submits a flexible working request. So questions that we might be discussing here: what are the legal risks if Tom dismisses Sarah immediately? It could be seen as in response to that flexible working request. That could be something that presents us with some heightened risk. If she has been a long-term sufferer of stress, then there could potentially be a disability discrimination claim here. And if we allow this to sit out and we don't do anything until that sick note ends after the 6-month period, then she's going to have the ability to claim unfair dismissal. So what processes should have been followed during those first 8 weeks? Well, we should have been checking in. We should have been setting out what the expectations for the role are. We should have been documenting those conversations, and also issuing early doors warnings if this wasn't going particularly well. What steps should Tom make now before making any dismissal decisions? Well, he should be coming to talk to all of you lovely HR people to make sure that he doesn't do anything to set this situation on fire that requires a cleanup rather than some proactive planning. Could this dismissal be defended in tribunal, and what evidence would be needed? If Tom followed through on this now and dismissed without any further intervention, it would be something that likely would have some difficulties being defended, depending on what Sarah's medical situation is, and also if she's able to link it to that submission of the flexible working request. So what will we do differently if we're in day one of Sarah's employment? We'd probably be matching out perhaps bi-weekly meetings to check in on progress, so informal one-to-ones with line manager, perhaps a check-in once a month with HR, and also making sure that if after those first couple of one-to-ones things are not going well, that we then set a formal review meeting with her to set out either some KPIs or some goals for her to try and achieve, but letting her know that it's not going particularly well and that we are going to have to perhaps work with her a bit more closely, look at offering some training or support to see if we can get that situation to improve. So manager do's and don'ts for quick reference. So do escalate to HR immediately when performance or conduct concerns arise. Document every concern with specific examples, dates, and impact on work. Conduct regular one-to-ones with written notes, especially during probation. Provide clear feedback and reasonable improvement opportunities. Seek HR approval before dismissals or contract variation discussions, and treat all employees with procedural fairness regardless of length of service. Don't assume probation provides freedom to dismiss without proper process. Make dismissal decisions without documented evidence or HR consultation. Threaten dismissal or redundancy to pressure contractual changes. Rely on verbal warnings alone. Always follow up in writing. Make promises about contract terms without authority to do so, or discuss exits or changes informally without proper consultation process. We should also ensure that we have clear escalation triggers in place as well. So key takeaways, have a think about your probations. What processes do we need? It's not a dismissal-free zone. We need fair processes and we need to document concerns and warnings. Early dismissals are high risk. So every termination carries tribunal risk these days. Poor processes in those first few weeks can result in costly claims. And changes need to be planned. So have a look at your contracts now. Is there anything that needs to be changed, updated? Do you need these to be professionally reviewed to make sure that when we get to that point where we can no longer make the changes that perhaps we would want to, that we are happy with the documentation that we are giving to employees when they join us? So your action points from this session: review your current probation procedures and ensure managers understand process requirements. Have a look at perhaps some training for your managers. Implement mandatory HR consultation before any dismissal or variation decisions. Update documentation standards and provide training on contemporaneous record keeping. Establish clear escalation protocols and decision-making authority limits. And audit recent dismissals or contract changes to identify, actually, if this new law had applied then, how would we have done and what do we need to do going forward to make sure that we're not tripping ourselves up? What we will make available to you after the sessions, in addition to this deck, there'll be a recording of this session. We're also going to provide policies on contract variation and a probation policy, some sample clauses around probation periods and contract variations for your forward-looking drafting ready for the new provisions coming in, and also an audit checklist for employment contracts and hiring practices. So we've absolutely flown through this session. We've covered a lot in half an hour. And as I've said, we will be putting this out as one of our e-learning courses, and it will be a full hour to be much more depth, and also will be at a bit of a slower and more manageable pace. I can see that we've got quite a lot of questions, so what we will do is we will take those questions down, and we will come back to you individually after the session as well, because I appreciate we've only got a couple of minutes left, but I'm just going to see if I can fire through a couple of those now. So Rachel, would you consider reducing probation periods to less than 6 months? I mean, it's not going to necessarily protect you legally because the 6-month limit is going to be there regardless. But in terms of getting managers into the habit of doing this quicker and making sure that we're not leaving things to the last minute, I'd say that's probably something that's a good proactive step to take. So look at maybe 3 months and then saying probations can be extended to 6. But then again, it also depends on the role. So if it's a technical role that requires somebody time to bed in, rather than, you know, if we've got roles where we're expecting someone to hit the ground, 3 months, great. If it's a role where we know someone's got some growth to do and it's a development role, we might need to think about whether that's reasonable. Lindsay, so ultimately, if someone is fairly and comprehensively consulted but does not agree to the changes, you need to make what are our options. If it's one of those restricted changes, if they won't agree, we won't be able to implement those changes. They are restricted, they are banned. If it's a non-restricted change, then we will be able to force those changes through. We just need to make sure that we're following now what is essentially a statutory fair process. Amanda, recorded session will be sent out afterwards. Yes. Ruth, if you need to change someone's working hours, so same number of hours but different days, and you give notice and consult, is that still restricted if they say no? This happens regularly to meet business need. So yes, potentially. So what we need to think about here is with these types of contracts is do we need to make it clear that somebody works, for example, 20 hours in a week, but the days and the shifts are changeable? So we need to be very clear on the terms that we're contracting people on and making sure that that flexibility is reflected in the contracts. Because if we're employing someone 20 hours and they're going to work fixed shifts and then we want to try and change them, that would be one of those restricted changes. I think I've got to most of those. But if there is anything we've missed, we will just have a quick look through before we end the session, and we'll come back to you individually. But thank you so much for joining this session. Appreciate it's been very, very fast. So like I say, we will release the recording as well, so you can watch it again at your own pace. And if there's anything that you think that we can assist you with, whether it is HR SaaS platform, whether it's e-learning, whether it's consultancy, we're here to help with a wraparound service. And you know, it's always lovely when I get to follow up with people individually after these sessions and take your feedback as well. So thank you very much. You're all free to get on with your days. Don't forget, we've got session 2 in just under 2 weeks, I think. So hopefully we'll see most of you back with us then. But thank you very much.